We will be discussing the latest cases impacting the employment law landscape in South Africa. My name is Lusanda Rapulu. I'll be facilitating this morning's employment law update. Before we begin, I would like to run through a few housekeeping matters, which will hopefully enhance this webinar experience for all of you. As participants, you are all automatically muted and the chat functionality has been disabled. So should you have any questions during the webinar, please make use of the Q&A tab at the bottom of your screen. Your questions will be submitted to me and I will select a few questions to discuss with the panel at an appropriate time during the webinar. Please note that we will not be providing written responses to questions. This webinar is being recorded and a copy will be made available on our website at www.bowmanslaw.com. In addition, for the first time, we will be sending you a high-level summary of the cases that I discussed this morning, with the key takeaway legal principles highlighted for you. We trust that this will improve your experience of our employment law update. The summaries will be provided to you early next week, so do look out for that. Without further delay, let's begin. The first case that we will be dealing with this morning deals with the topic of improperly obtained awards. In this regard, Ayanda Ngabinde, who's a senior associate in our employment team in Johannesburg, will be dealing with that case. Over to you, Ayanda.
Thanks, Lusanda, and good morning, everybody. Thank you for joining us. The first case with which I'll be dealing is Rand Refinery Pty Limited versus Matome Victor Sehunani and others. Now, just a general comment before I dive into it. It's quite an important case because, ordinarily we deal with review applications which are brought in terms of Section 145, subsection 2A. And that's where the commissioner commits misconduct or there's an irregularity or exceeds his powers. But in this instance, we deal with a review application brought in terms of 145 subsection 2B. And that's where the main allegation is that the award has been improperly obtained. Now, over to the facts. In May 2017, we have Mr. Maseko, who was dismissed by the company for theft of gold bars. Mr. Maseko then refers an unfair dismissal dispute to the CCMA, and the CCMA comes to the conclusion that his dismissal was in fact procedurally and substantively fair. So the referral is dismissed. Now, what's important to our set of facts is that at the CCMA, one of the witnesses was the company's employee by the name of Mr. Mulafi. Now, fast forward a few months, Mr. Maseko launches an application to review and set aside the award in the Labour Court. But at this stage, it's based on the fact that the commissioner had either exceeded his powers or committed misconduct or committed a gross irregularity. So falling within section 145 2A, which is what we regularly have. And that review application subsequently goes through the motions, and eventually there's a set down date for some time in 2021. Now, in the intervening period, Mr. Mulafi, who had testified at the arbitration at the CCMA in Mr. Maseko's dispute, Mr. Mulafi is dismissed by the company. And he's dismissed for incapacity, and the dispute goes to the CCMA. It ends in a settlement agreement. But in the subsequent months, Mr. Mulafi, he goes on what's called a smear campaign against the company. And he essentially alleges a whole bunch of dirty dealings on the part of the company. What's perhaps most important is that he says that he was cajoled or persuaded by the company to perjure himself in various arbitration proceedings or disciplinary hearings of other employees. And of course, one such hearing or one such example was that of Mr. Maseko, who is at this point currently in the Labour Court. So the company obviously catches wind of all of this, and they launch an application in the High Court to interdict that conduct, and subsequently an interim order is granted, and the parties file their respective affidavits in that particular matter. A few months later, Mr. Mulafi, who is still awaiting his return date in the High Court, he appoints legal representatives. But it's not just any legal representatives, it's the same representatives who represent Mr. Maseko in his labor court review application. And obviously the representative sees the connection between these matters, and subsequently he says to Mr. Mulafi, well, let's go to the High Court and file a supplementary affidavit, basically expanding on the allegations that you made in that court about the company's dodgy dealings in respect of its proceedings. So subsequently, that affidavit is filed, and Mr. Maseko at this point is about 3 weeks away from his labor court review application being heard. So 3 weeks before that hearing, Mr. Maseko applies to amend his application, his review application. Obviously, he's now caught wind of what's happening with Mr. Mulafi. And so he applies in terms of Rule 11 of the Labor Court Rules. And basically, what he says is that I now believe that the award has been improperly obtained in terms of Section 145, subsection 2B. And this is on the strength of the affidavits of Mr. Mulafi, who of course has said that he has perjured himself in relation to a number of disciplinary proceedings, but of course, including Mr. Maseko's. So on that basis, so Mr. Maseko argued, the award has been improperly obtained. So Rand Refinery opposes that application, and a few days before the hearing, they emailed their submissions to the court. The reason I mentioned that is because it does become relevant in the labor court proceedings. So that's essentially where we are. We have this Rule 11 application to amend the original review application, arguing that the award had been improperly obtained. So at the labor court, what the judge found was that Rand Refinery had in fact failed to file an answering affidavit to the Rule 11 application. And so as a consequence of that, firstly, the Rule 11 application to amend had to be granted. And then the allegations in those affidavits in the High Court now went untested. And so there was prima facie proof that Mr. Mulafi had in fact perjured himself. And so as a consequence of that, the judge concluded that the award had in fact been improperly obtained. And so she decided that the matter should be remitted to the CCMA to be reheard. So that was the judgment in the labor court. The company subsequently tries to appeal to the Labor Appeal Court, but they're unsuccessful, and eventually they go all the way to the Constitutional Court. So the Constitutional Court makes a number of findings. The first one is that the opposing affidavit to the Rule 11 application had indeed been filed. So that's their starting point. But then the Court says that even if it had not been filed, the judge wasn't entitled to decide the Rule 11 application simultaneously with the review application. So in other words, after the judge had said, okay, I'm allowing you to bring this new case and to admit this new evidence, being the affidavits in the High Court hearing, the judge ought to have provided the company with an opportunity to respond to the new case. But the judge did not do that. Of course, the judge dealt with the matters altogether. But then the ConCourt goes on to say that even if those issues could be dealt with simultaneously, the judge still made a mistake because the only thing that she had considered was the affidavit of Mr. Mulafi, and she had no regard to the other affidavits that had been filed by the company in the High Court dealing with those particular allegations. So essentially, the judge had taken Mr. Mulafi at his word and considered nothing else that the company had pleaded in the High Court. And then what the judge also said, or what the ConCourt also said, was that an affidavit that's deposed to in different or earlier proceedings is hearsay. So the judge couldn't even attach as much weight as she did to that particular evidence. In fact, the correct process would have been for Mr. Mulafi to depose to a new affidavit before the Labour Court. But in particular, in respect of the section 145 subsection 2B finding, the judge said that the award could not be set aside simply because there was the possibility of perjury being committed. The judge said that in order for a party to rely, or for a court to conclude that an award has been improperly obtained, the judge in that court must make a factual finding on the allegations. So in other words, the Labour Court judge had to factually find that Mr. Mulafi had in fact perjured himself. And on the evidence, the judge had not conclusively made that finding. That finding had to be made on a balance of probabilities. And so as a consequence of all of that, the matter could not be remitted to the CCMA to be re-arbitrated, but instead, the Labour Court judge, when seized with the Section 145 2B application, has to make the factual finding and has to make the determination then and there. So yeah, that wraps up the Rand Refinery case. Quite an important judgment because it sets the test and the relevant principles for, among other things, Section 145 subsection 2B review applications. Thank you.
Thanks very much, and interesting facts and interesting judgment. The next set of cases that we are going to be dealing with deal with the topic of constructive dismissal. The first one will be dealt with by Ayanda, and the next two will be dealt with by Melissa Koga, who's a senior associate in our Cape Town office. Back to you, Ayanda.
Thank you again. Yes, so the next case with which I'm dealing is an unopposed review application in the Labour Court. It is Browns the Diamond Store Pty Ltd versus CCMA and two others. Now, the background facts to this begin in March of 2020 with an employee by the name of Belinda. She was at the time 59 years old and she was a sales consultant. Of course, in March 2020, we also had the onset of the COVID-19 pandemic. And as a consequence, the company consequently or temporarily laid some people off on a temporary basis. So they couldn't work for a certain period. Now, during that period, Belinda approaches the company and she says, well, look, what I'd rather do is apply for voluntary retrenchment. The company says, well, no, she's too important to them, and their policy is that they would not retrench people who are on the cusp of retirement. So Belinda is annoyed by this. In fact, she's more than annoyed. She is made irate by this response. And she sends a tirade of letters and emails to the company regarding, its senior personnel. She refers to them as rude and disgusting. She calls them soulless individuals. And among those allegations, she threatens to tell the EFF about the company's conduct in not allowing her to be voluntarily retrenched. So In that period, at some point, she's issued with a warning, which she doesn't dispute. But of course, she carries on in the same vein. So in September 2020, the company decides that they're going to formally charge her. And so they do that. They charge her with insolence, but she refuses to go and collect the charge from the employer's premises. Instead, what she does is she falls ill, and for a month she's off work. She's on sick leave, and at this stage, the company's gearing up to reopen its doors. So in late October 2020, Belinda becomes aware of a rumor, or she receives word from one of her colleagues that she is about to be dismissed. And so as a result, she's not included on the company's sort of reopening roster, the new shifts that would be allocated to people upon the reopening. So she hears this rumor, and she promptly decides that she is going to resign. So she sends an 11-page letter of resignation under the advice of her attorneys. And subsequently, after she resigns, she refers a constructive dismissal dispute to the CCMA. The CCMA considers the facts, and they say, yes, Belinda was in fact constructively dismissed by the company. The company, of course, takes it on review at the Labour Court, and as I said, at the Labour Court, it was unopposed. So the Labour Court confirmed a few principles, the first of which is that in order to prove constructive dismissal, there's quite a high bar for an employee. So essentially, what an employee has to prove is that they could not have reasonably been expected to cope with the particular environment that they were in. So in analyzing this, in analyzing Belinda's case, the Labour Court expressed some surprise at the conclusion reached by the commissioner, because he had made some factual findings that were correct. You know, he had said that Belinda was the author of her own misfortune, and that her emails were, you know, unacceptable, and they had impacted the trust relationship. So the court didn't quite understand how the CCMA could come to the conclusion that there was a constructive dismissal. But what was key for the Labour Court was the fact that Belinda had admitted that she had resigned after hearing that she would be dismissed. So it wasn't so much to do with the environment and things like that. It was a response to pending disciplinary proceedings. And so the Labour Court found that that Belinda could not prove that she was constructively dismissed, and as a result, the CCMA did not have jurisdiction to hear the dispute. So yeah, another important case for just restating the principles for constructive dismissal, and if not that, then a pretty interesting set of facts. So thank you, Lusanda.
Thanks, Ayanda. Melissa?
Thanks very much. Good morning, everyone. I'm going to be discussing the Mukutshulwa versus the Department of Health Eastern Cape case. It is a decision of the Labour Court from the 4th of April this year. And in that case, the employee was an assistant director at the Department of Health in the Eastern Cape and had resigned and claimed constructive dismissal on the basis that the employer had created an intolerable workplace. And the reasons that she submitted for the intolerable work environment that was created by her employer largely related to the conduct of her manager. And she gave evidence that her manager had marginalized her in that he didn't allocate any work to her. And so she found herself doing nothing for a number of months. This affected her so much that she was admitted into a psychiatric institution for 3 weeks. And she did bring these issues to the attention of the superintendent. And as a result, she was temporarily reassigned for a period of 6 months into an extended public works program. However, at the end of that reassignment, no further solutions were implemented by the department. And she returned to her old situation where she was left with lengthy periods without work. She was given no workstation and she had to sit in a passage and do her work. She had so much time on her hands that she actually enrolled to further her studies because she needed to keep herself busy at the workplace. And she made a number of complaints and grievances about these working conditions to the department because she wasn't given any support in order to enable her to meet her key performance areas. And so her case was that the employer had an obligation to ensure that she was given work in order to develop her expertise and to meet her KPAs. And paying her monthly salary was not enough. So the court there found that the employee had proved that the cumulative effect of the employer's conduct via its managers and its employees had made her continued employment intolerable. And therefore, this amounted to an unfair constructive dismissal. So a takeaway from this case is that it's not enough to just pay your employees. There is actually an obligation to provide work to your employees. And if you do not provide work in order to enable employee to meet their key performance areas, then there has to be a good reason for you not doing so. If you don't, an employer may have found to have created an intolerable work environment, and that therefore places the employer at risk of a constructive dismissal dispute. Now, the second case that I'm going to discuss, which also pertains to constructive dismissal, is the case of Sanlam Life Insurance Limited versus Mokomatsi and others. It is a decision of the Labour Appeal Court, and it was just handed down a few weeks ago in August. And this case has actually been making quite a lot of interest in news articles and commentators, where the Labour Appeal Court found that an employee who alleges constructive dismissal as a result of their mental ill health has to prove that the employer knew or ought to have known the existence of their mental health in order to make their continued employment intolerable. So in that case, the employee had resigned from Sanlam and referred a constructive dismissal dispute to the CCMA. He was not successful in proving his constructive dismissal dispute at the CCMA, and he then took it on review to the Labour Court, where he was actually successful. And the employee said that the commissioner failed to consider relevant evidence, which included that he was suffering from mental ill health at the time of his resignation. And the Labour Court frowned upon the fact that the commissioner had failed to give weight to the employee's mental health during the arbitration process, and the employer had not considered any sort of incapacity or ill health process rather than a disciplinary process in the run-up to the employee's resignation. Instead, the Labour Court found that the employer had swept the fact of the employee's mental health under the carpet at arbitration, and found that the employee had proved that the relationship was indeed intolerable and was a constructive dismissal. And the court ordered the employer to pay 4 months' salary as compensation. But that wasn't the end of the matter, because Sanlam then took the case on appeal to the Labour Appeal Court. And there, the employer argued that the issue of mental health was never evidence that was before the commissioner. And obviously in the Labour Court, when you take a matter on review, you're confined to the evidence that was served before the commissioner in the arbitration process. And so the Labour Appeal Court found that because there was no evidence, the commissioner could not make a decision that there was constructive dismissal on the basis of ill health or incapacity. And the employer argued that it was never called upon to meet a case of constructive dismissal based on it having made the employment relationship intolerable by not treating the employee with the necessary sensitivity. So the Labour Appeal Court placed emphasis on the fact that the employee had only submitted a medical certificate after he had resigned. And on that medical certificate, it stated that he had resigned due to his stress. So the employer was not actually aware that the reason that he was misconducting himself in the workplace was because of his mental health. There was knowledge of mental health issues way before the time of allegations of misconduct, but there was no further information in relation to the fact that their mental health issues might have been continuing after the death of the employee's mother. And the Labour Appeal Court held that the facts of the case must point to employer having been made aware or ought to have been made aware of the mental distress of an employee. So it's only if an employer is aware of an employee's psychiatric illness and is then indifferent or insensitive to that mental ill health could this potentially make continued employment intolerable, and then a constructive dismissal case could be established. So the court importantly said that employers must always be vigilant and act sensitively when it becomes aware of a particular susceptibility or vulnerability of an employee in the workplace. And in a case where an employee claims constructive dismissal based on psychiatric or mental ill health, the employee must prove that the employer was aware or ought to have been aware of the employee's psychiatric ill health. So in this case, the Labour Appeal Court found that it was not common cause that he was suffering from mental ill health, and there was no evidence of mental ill health that was presented at the arbitration process. To the extent that there was sick leave that was taken by the employee, he had informed the employer that the reason he had taken sick leave was because of flu and not because he was suffering from stress and anxiety. So key takeaways from this case is that when an employer becomes aware of an employee's mental ill health, it should be vigilant and deal with that employee sensitively. And this includes taking into account what their known mental ill health is and how to deal with that if issues of poor work performance or misconduct arise in the workplace. And in certain circumstances, it might be appropriate for an employer to consider an incapacity for ill health process. However, if an employer does not have the information about an employee's ill health on the basis of psychiatric reasons, then there's not much it can do. It can only deal with an employee on the facts that it's known to it. And if an employee misconducts itself, then an employer can rightly discipline that employee. And the employee can't then state that they've been constructively dismissed because there's no evidence to show that it made the employer aware of their mental ill health. Thanks, Lou.
Thanks, Melissa. Two questions for you from the audience. The first one is in relation to the Mkuchulwa case. The question is, did the employee in Melissa's first constructive dismissal case lodge a grievance and follow all internal measures to resolve the issues before resigning?
So the facts of the case aren't particularly prescriptive on what kinds of grievances she lodged, but the court found that she had made the department aware. She had at least brought the attention to the issue to the attention of the superintendent, who had temporarily reassigned her, and the facts say that she made complaints and grievances. So I would assume that she did follow the internal processes to lodge a grievance. So in this case, it wasn't as if the department was not aware at all that this was happening. In fact, it took steps temporarily to try and ameliorate the situation, but those steps were not enough.
Thank you. Your second question, does the employee have to provide a medical report showing to the employer that he has mental health issues? What if he does not submit such reports during a disciplinary hearing, but only brings this at arbitration?
Yeah, I think if an employee only brings it to the attention of the employer at arbitration, this is after the fact, so it's not something that could be taken into account by the arbitrator, firstly, or the employer, because the employer wouldn't have known this at the time. And I would say that if an employee is relying on claims that they're suffering from mental ill health, that they ought to provide proof of their incapacity. And if they refuse to do so, then the employer can only make a decision based on the facts that's known to it. So there would be a negative inference if an employee refuses to provide a medical certificate or to submit to a medical examination at the cost of the employer.
Thank you. Thanks, Melissa. Moving on from the topic of constructive dismissal, the next three cases we're going to be deal with the issue of dishonesty. The first case will be dealt with by Melissa, and the next two cases will be dealt with by Sbusiso Dube, who is a partner in our employment practice in Johannesburg. Thanks, Melissa.
Thanks, Lusanda. So the first case that I'm going to be discussing for the dishonesty is Tuguzu versus the CCMA. It is a 2023 decision that was heard earlier this year in June from the Labour Court. And this case dealt with a waitress at Chef's Warehouse Maison Estate, wherein after a transfer of the business as a going concern, the new employer implemented a new policy regarding the distribution of gratuitous tips that were received by waitresses. Now here, the waitresses earned a salary that was in terms of their contract of employment, but in addition to their salary, they would on occasion receive gratuities and tips from the patrons of the restaurant. And the restaurant consulted its staff on a new policy that it was going to introduce, where the waiters and waitresses would have to declare the tips that they received so that 25% of those tips could be distributed evenly amongst all staff, including the back-end staff in the kitchen, who all contributed to a positive experience of the patrons. Now, this particular waitress in question refused to agree in writing to the new policy, but did ultimately verbally agree that she was going to comply, and did for a period of time declare certain of her gratuities that she had received. But for a few days in February, she did not declare her gratuities and claimed that she did not receive any gratuities for that period of time. And when the employer inquired with certain of its customers whether they had actually provided the waitress with a tip, the customers confirmed that they had in fact given her a tip, and the waitress denied this. One of the patrons had a business relationship with the restaurant and agreed to give evidence at the inquiry, but the waitress claimed that the patron was lying and that she had never agreed to a change in the policy. Now, the court found on review that the employee's version was completely at odds with the probabilities, and the court found that it couldn't be disputed that the policy was in existence and that the employees were consulted prior to its implementation. And the fact that she did not agree in writing with the policy didn't mean that she wasn't consulted. And there, the court found that the policy did not in any material respects alter the employee's terms and conditions of employment. The employee in question had not referred to any term of her contract of employment that she claimed had been changed, and the gratuity was not a right or entitlement that was specified in her contract of employment. The policy was also meant to benefit all employees, inclusive of the individual herself, where she herself had also benefited from her colleagues declaring their tips and sharing in the spoils of their work. And she therefore sought to comply with the policy as and when it suited her. So takeaway from this is that the court takes seriously acts of dishonesty. In this case, the employee refused to be upfront about declaring her tips and then denied that she even received a tip from one of the patrons. And in this case, it shows that a court will more readily find that a dismissal is substantively fair in circumstances of dishonesty. Thanks, Lusanda.
Thanks, Melissa. Before I let you go, you've got one more question back to the Sanlam case on constructive dismissal. The question is, for the Sanlam case, did the court provide guidance on whether disciplinary proceedings should be suspended or stopped if mental health issues are alleged during the disciplinary proceedings?
They did not provide guidance on that. So what the court has said is that you should treat it sensitively, but if medical evidence comes to the attention of the employer, it is advisable for employers to tread with caution and to investigate the veracity of the medical claims made by an employee. So it may, in certain circumstances, be suitable to do so. And we do find that often in disciplinary inquiries, in the lead up to an inquiry, employers often receive medical certificates saying that the employee is booked off for stress or anxiety. And also the employer needs to be able to ascertain, is the employee just suffering from stress and anxiety because it's naturally a very stressful situation to be put through a disciplinary inquiry? Or is this person producing evidence to the effect that they have been treated for mental health issues over a sustained period of time, that they've been consulting with a specific medical practitioner to assist them and receive treatment to that effect, and when this was brought to their attention and why it was not brought to their attention earlier? So it really depends on the circumstances of the case and the medical reasons relied on by the employee. If they're simply putting in medical certificates to postpone an inquiry, then that obviously must be treated with caution. But if something more serious, where there's a specific medical diagnosis saying that this person suffers from ongoing severe depressive disorders, then that might be something to warrant a further investigation into potential incapacity for ill health.
Thank you. Thanks, Melissa. Sbu?
Thanks, Lusanda, and good morning to all the participants. I'll be covering two cases today that deal with dishonesty, both very interesting in their own rights. The first case, I think it's quite a popular case. It's SARS versus CCMA and two others. Now, in this case, we have an employee, Mr. Mathebula. Mr. Mathebula, on the 6th of September in 2020, in the morning, sent in a message to his supervisor where he indicated that he wasn't feeling well and he wouldn't be able to come to work. Now, on the basis of him saying he's not feeling well, the supervisor told him it's okay, he can stay away from work, and his sick leave, or rather his leave, would be captured at a later date. The following day, he sent a message again to his supervisor saying that he's still not feeling well and that he wouldn't be able to come to work on that day. Sorry, the first day was 7 September. So on the 8th, he sends another message saying he's still not feeling well. His supervisor was then quite worried about him and advised that perhaps he should go and see the doctor. So Mr. Mathebula responded and said that, you know, if he's still not feeling better, he will then go and consult with a doctor. On the 9th of September, Mr. Mathebula then went to consult with the doctor. The doctor gave him a sick note and booked him off from the 9th till the 11th of September. He then went back to work, and it's not clear from the case, but at some stage, while his manager was watching the 7 p.m. news, his manager actually saw Mr. Mathebula engaged in a protest that the EFF had arranged against Clicks. So Mr. Mathebula was seen at Sandton singing, clapping, and really just not looking like a sick person. So his manager then went to YouTube to get a bit more evidence, gathered some more clips, and then confronted Mr. Mathebula with this. So in a letter, or rather in an email, told Mr. Mathebula that, look, I was watching the news and I actually saw that on the days you said you were sick, you were involved in a protest. In response, Mr. Mathebula's first response was, who told you that? Or where do you get that from? So he didn't really respond to the allegations against him, but he was more interested in how he had been found out. He later stated that, look, his friend came by, he was feeling much better. He thought that, if he goes to Sandton and stretches his legs, it might actually help him, but it didn't help him, and he felt sick again the following day, which he then notified his manager about. So he was then taken to a disciplinary hearing where he was charged for dishonesty. At the disciplinary hearing, he was dismissed, and the matter then went to the CCMA. At the CCMA, the commissioner, for some strange reason, found that the dismissal was substantively unfair. So the company then took the matter on review to the Labour Court. At the Labour Court, I think the court really just hammered on the fact that he was clearly trying to mislead his employer. If he had been sick, he wouldn't have been found at a protest singing and clapping. I think the judge actually said if he was well enough to sing and clap, then he was well enough to go to work and work. So the question really for the judge was about the extent at which he claimed he was indisposed and whether or not he was probably indisposed. And the judge felt that the probability is that he misled his employer because he was aware that if he had given the real reasons for wanting to be absent, then the employer would have said no. And more importantly, there was absolutely no evidence to prove that he was sick on the days that he claimed he was sick, because the medical certificate had booked him off from the 9th to the 11th. And what the commissioner had done was the commissioner made an assumption that because the doctor had booked him off from the 9th to the 11th, that he was probably sick on the 7th and the 8th. And the judge said, you know, the commissioner could not make a decision based on an assumption. There was no evidence to this. And because the decision was based on the commissioner's assumption, this was a reviewable irregularity. One of the important things I think that the judge mentioned in this case was around the medical certificate and the fact that, you know, the medical certificate was actually hearsay because there was no affidavit from the doctor who allegedly had consulted with the employee. And I thought this was quite important for employers to bear in mind. You know, we always faced with situations where employees are taken to disciplinary hearing, they submit a medical certificate, and that's the end of the story. So the judge in this case is actually saying, well, that's not good enough. You should, at the very least, get an affidavit from the doctor who treated you, or in extreme cases, the company can even insist that the doctor must actually come and give evidence at the hearing. So the review was upheld and the company was successful in this case. The next case, very strange case, is Amku versus Biesnar and 2 others. In this case, the employee was essentially charged with dishonesty arising from something that was said in his particulars of claim and in a case where he was suing the employer for defamation. So what happened here is the employee had been previously suspended. He was suspected of having stolen the employer's disciplinary records. He was suspended, there was an investigation, and the investigation cleared him of any wrongdoing, and the suspension was then uplifted. Pursuant to the suspension being uplifted, he then lodged a grievance claiming that the company had unfairly discriminated against him. There was another investigation, and the investigation came back and cleared the company of any unfair discrimination. I don't know what the grounds for discrimination would have been, but we know that there was a grievance for unfair discrimination. Now, he was obviously not happy with that finding. He then decided to issue summons for defamation, claiming that the company had defamed his character by accusing him of theft. The summons was then issued by his attorney, and the particulars of claim as well were drafted by his attorney, and they were signed off by his attorney. It seems like there was not much consultation between the attorney and the employee because the summons referred to the employee having been dismissed. Now, when the company was served with the summons, they felt that the employee was misrepresenting the facts and that the employee was acting dishonestly for claiming that he had been dismissed when in fact he had only been suspended. The employee was then charged for dishonesty and misrepresentation. At the disciplinary hearing, the employee's evidence was that he had not instructed his attorney that he was dismissed, but rather that he had instructed his attorney that he was defamed arising from his suspension. So the attorney had actually made a mistake in the particulars of claim. It seemed like his attorney was not allowed to give evidence at the disciplinary hearing, so the chairperson did not believe or take note of the employee's version of events, and the employee was then dismissed. At the arbitration, the attorney came and testified, gave evidence that he hadn't obtained proper instructions, that he had made a mistake. The employee had never instructed him that he was dismissed. He's not a labor lawyer, and he basically took all the blame and said that he had signed off on the particulars of claim without the client's go-ahead. The client also testified, or the employee also testified to this effect. They were not cross-examined about this. There was no dispute about their evidence in cross-examination. And despite this, the arbitrator found that the dismissal was substantively fair. So the employee was then unsuccessful at the CCMA. There were no credibility findings made by the arbitrator. In fact, the arbitrator did not in the award give any reasons why. He blatantly ignored the evidence that was given by the employee's attorney and the employee. So at the labor court found that this is definitely a decision that stands to be reviewed and set aside for the reasons that I've indicated. There was nothing from the arbitrator about why the attorney's evidence was not taken into account. In fact, the court went on to say, this was quite a straightforward matter, that the company could have just called the employer's attorney, and on calling the employer's attorney would have discovered that it was the attorney's fault that had led to the particulars of claim. The particulars of claim could then have been amended, and this would have been resolved. So the arbitration award was set aside with an order that the employee must be reinstated. I think what's important for me, what's interesting for me here is it seems clear to me that there is no good relationship between the parties. There's just been a concerted effort really from the company, in my view, to dismiss this guy arising from these allegations. And I don't know if this is one of those cases perhaps where it should have been considered whether or not reinstatement is appropriate under the circumstances. But this is me just thinking out loud. But I suspect that this is not the last we'll be hearing from Mr. Tlhaganyane and Assmang Limited. Thanks, Lou.
Thanks, Wu. My thinking out loud, a lesson there for attorneys to take proper instructions.
Yes, certainly.
A question, Wu. SARS case. In an event where the employee was on sick leave as a result of them being involved in an accident, what would happen in a situation where the employee is seen on TV partaking on strike whilst they are in their crutches? I assume that the employee might indeed be sick.
Yeah, very interesting. I mean, I think it would really depend on the medical report, right? So why are you not at work? What is it that's preventing you from tendering your services, right? So if, for example, you're on medication, so if you tell your employer you're on medication, you're sleeping the whole day, but then we see you on TV not sleeping and being quite active, then you might have a case to answer for yourself. If you tell your employer you can't stand, right, but then we see you actively engaged in this protest. So I think we'd have to consider the circumstances of each case. But I really think what employees need to do is take sick leave because you are sick, not because you want to be engaged in other activities, right? If you want to be engaged in other activities, take annual leave. You know, your employer doesn't really care what you're doing with your annual leave. So let's rather just take sick leave for the purpose of taking sick leave, and let's not be dishonest.
Thanks, Wu. Still on the SARS case, out of interest, I Googled the doctor who issued the questionable medical certificate in the SARS case. It turned out that the doctor was indeed a medical practitioner, but he was a member of parliament for the EFF. As the judge had also expressed misgivings about the medical certificate, can an employer in such a case bring an action against the doctor for issuing a dodgy sick note?
I mean, what makes the sick note dodgy in this case is that the judge says, you know, you can't really make out what the diagnosis is. There's no proof that the employee didn't actually go and consult this person. And I just think the company doesn't have time to do that. I think if you're going to be bringing a case against the doctor, you need tangible evidence. So it can't really go on, you feel like the medical certificate looks dodgy. So that's not something I would advise under the circumstances.
Thank you, Stu.
I see there's a comment that says one of the options would be to refer the doctor to the Medical Health Council. Yeah.
Thank you. We're now moving on. We're moving on to the topic of breach of contract. In this regard, we'll be dealing with one case. Nadine Mather, who is a partner in our practice in Johannesburg, will be dealing with that case. Thanks, Nadine.
Thank you very much, Lou, and good morning, everyone. This case, Lutrana versus Minister of Human Settlements and another, was heard before the Labour Court and Acting Judge Makura. And in this matter, the employee, around 62 years of age, was employed by your department as a Deputy Director General for Corporate Services. And by virtue of her position, she was regarded as a member of the Senior Management Service that I'll refer to as SMS going forward. Now, as a result of her employment contract, she acknowledged and agreed that she was part of SMS and that the SMS handbook applied to her contract of employment. Now, on the evening, or on at least one evening in March this year, the minister got stuck in a lift at the department. And she sent a message on a WhatsApp work group seeking assistance on the basis that she was stuck in this lift. Now, within 1 minute, the employee contacted the facilities and securities representative and asked them to contact the service provider who maintains the lifts to urgently attend to the matter. She then immediately received a call from the Acting Director General informing her of the incident, to which said she was aware of it. She had already contacted securities and facilities, but notwithstanding this, she contacted other representatives to ensure that security would attend to the matter and to assess what was happening at the lift, and also further engaged facilities and securities, who then confirmed that the service provider was sending a technician and they were on the way to the building. Now, the employee did all of this and contacted all these representatives within 3 minutes of the WhatsApp message being sent on the group by the minister. And the minister was trapped in the lift for just over an hour. The next morning, the employee arrived at work and was immediately called into the minister's office and was issued with a letter of intention to dismiss for misconduct. And the allegations against her included, amongst other things, that she had failed to timeously respond to the incident in which the minister was trapped in the lift. She had failed to ensure the maintenance of the lifts, even though she was engaged in the position of Deputy Director General Corporate Services. She had failed to ensure that people's lives weren't at risk as a result of the lift, and that this incident could place the department at risk in respect of litigation proceedings. She was asked to furnish a written explanation as to why she should not be dismissed. The employee, of course, denied any sort of wrongdoing and any misconduct. And she said, in any event, the appropriate forum in which to deal with this is before a disciplinary hearing in which the allegations can be tested. Now, the minister thereafter called her to a meeting and said to the employee, you have three options. Either we are going to dismiss you. Second option is to have a disciplinary hearing and we'll place you on suspension, or you can take early retirement, because she was 62 years old. Now, the employer under protest did elect to take early retirement, but she did request that can it apply 6 months after the settlement agreement has been concluded. The minister didn't initially agree with this proposal and immediately placed her on precautionary suspension, pending finalization of the matter, and again arranged a further meeting to discuss this potential option of an early retirement. The employee attended the meeting. The minister elected not to do so, but instead sent representatives from legal services and human resources to attend the meeting. Nevertheless, the employee was driving back home after the meeting. She received a call from the minister who said, you have been dismissed. And shortly thereafter, she received a letter of summary dismissal. So, very unique set of facts here. We have an employee who literally reacted within 3 minutes to someone being stuck in the lift, who was only stuck in the lift for an hour. And she was summarily dismissed in circumstances where they were busy discussing an early option of retirement and simply received a phone call from the minister. So, I suppose the questions here are, when an employee is faced with a summary dismissal, before at least an agreed procedure in terms of the SMS handbook is received, what must the employee do? Must the employee refer an unfair dismissal dispute to the CCMA or the relevant bargaining council? Or can they approach the High Court or the Labour Court for a claim for specific performance of contract? Was the employee entitled to do both? Well, in this matter, the employee elected to bring an urgent application before the Labour Court, and she sought declaratory relief in terms of which the department had acted unlawfully in the dismissal and that they failed to comply with her contract of employment, which included the SMS handbook on the procedure for misconduct, that she wanted to be reinstated, and ultimately to compel the department to comply with the SMS handbook in carrying out her termination. The department opposed the application and raised two preliminary points, saying the court doesn't have jurisdiction to hear this matter, and secondly, in any event, it's not an urgent matter. Now, on the issue of jurisdiction, the department relied on various case law authorities which had to deal with unfair dismissal disputes under your regime under the Labour Relations Act. One of them appeared to be a breach of contract claim, but the true nature of the dispute was actually a failure to comply with your retrenchment sort of processes contained in the Labour Relations Act. But in this matter, the court said your jurisdiction is determined obviously factually, and it depends on how the case is pleaded. And here the employee's case was pleaded merely as a breach of contract claim. She did not seek to question the fairness of her dismissal under the LRA. It was a breach of contract claim brought under Section 77 of the Basic Conditions of Employment Act. And the court re-emphasized that the Labour Court does have jurisdiction similar to a civil court to determine a breach of contract claim over dispute of a contract of employment, and accordingly it did have jurisdiction in this case to determine the employee's claim. Moving on to the issue of urgency. The employee, amongst other various things, argued that she was 62 years old. She was 3 years away from retirement. She stood to lose all her employee benefits, and this would result in her not being able to repay her bank loans. And if she was not granted sort of immediate or at least urgent relief and only relief in the ordinary course, this would not be sufficient. She would not have an alternative remedy. The department gave the argument that most employers make to say, well, it's not unusual that employees would lose their benefits in a scenario like this. The horse is bolted, she's been dismissed, and she can bring a claim in the ordinary course, like many employees do. The court, in assessing urgency, found that the claim for specific performance is a remedy available in the breach of contract scenario, and the value of this remedy actually may be diluted if it is not sought as a matter of urgency, right? Specifically in this case, the court was sort of or at least mentioned the actual conduct by the minister and the fact that they had subverted binding procedures and your rule of law here really would was quite serious and would undermine any relief given in the ordinary course. If the employee, pursued it in the ordinary course, given our backlog in the courts, she may have already retired by the time it was heard. So in these specific circumstances, they felt that the matter was urgent and that it was necessary to hear it on an urgent basis. Now, just turning to the merits of the matter, again, the court emphasized, and what's important in this case is that it was not one concerning the merits of the dismissal. The only question the court was required to decide was whether the dismissal was effected in compliance with the employee's contract of employment. Now, the SMS handbook was a handbook that sets out terms and conditions for senior employees in the public service. It's determined by your Minister of Public Service and Administration, and therefore it is binding on all employers. And the SMS handbook regulated the procedure for misconduct in your public service. It provided, amongst other things, that you must have a disciplinary hearing. If you place an employee on suspension, a hearing must take place within 60 days, and you must appoint a chairperson specifically to hear the allegations. Now, in this case, the department, of course, argued it's a guideline. We were allowed to divert from the guideline. The court said, no, it is binding. And the minister breached this policy. Not only did they breach the procedure, but she acted as the complainant, the witness, the investigator, and also the chairperson in deciding to dismiss her. This conduct, therefore, was unlawful. It was found that they breached her employment contract, and in these circumstances, that an appropriate remedy was specific performance, because all the employee had asked to do was that she be reinstated to be entitled to a disciplinary hearing before the decision was made to terminate her employment. And the court also frowned upon the minister's actions and awarded costs against the department. So really just some key takeaways is in respect of a breach of contract claim, the Labour Court does have jurisdiction to determine such a claim, and specific performance is an available remedy, specifically on an urgent basis, as they found it can be diluted if it's not given on an urgent basis. And it really is dependent on how an employee pleads a claim. This claim was pleaded simply on the basis of a breach of contract, and an employer is bound to follow the contract in carrying out any sort of dismissals where the contract at least regulates the procedures for misconduct or dismissals.
Thanks, Nadine. Moving on to the topic of alcohol testing, also to be dealt with by Nadine. Thanks, Nadine.
Thanks, Lou. This judgment of Samancor Chrome Limited versus Willemse and others has been highly publicized, various news articles on it, and it really called into question the reliability of the use of breathalyzer tests to prove a contravention of an employee's alcohol or drug policy. Now, in this matter, Samancor subscribes to a zero tolerance approach in respect of alcohol and drugs, specifically given their business operations being a mine. And a person is deemed to be unfit to enter into premises where they have sort of their breath exceeds an alcohol level of 0%. So zero tolerance approach. If there was a positive alcohol or drug result, their policies provided that it would lead to summary dismissal for a first offence. Now, in this matter, an employee upon arriving to work was subjected to a breathalyzer test by the security official. And the breathalyzer test was positive. And the employee contended, no, this must be wrong. I haven't had any alcohol. And he questioned the result. And the security officer then tested him again with the same breathalyzer test and got the same result. They then used a different breathalyzer machine on the employee, and the result was again positive. So as a result of these three positive tests, and the second machine actually reading had a result of, I think, 0.013% alcohol level, they dismissed him summarily in accordance with their policy. Now, the employee again maintained he did not have any alcohol, and as a result, he decided to go to his medical doctor and take a blood sample that was sent to an Ampath laboratory to be tested. And the test results came back negative. The employee then referred an unfair dismissal dispute to the CCMA. Now, as part of the evidence led at the CCMA, the employee got a pathologist to lead evidence who testified that the sort of method to determine your alcohol and your blood level systems and used at the laboratory can sort of only test for alcohol that is more than 0.1 grams per deciliter. So the report issued by the laboratory was negative, saying that he didn't have more than 0.10 grams in his blood. The pathologist tested that the blood test was more accurate, that breathalyzer tests may often be false and generate false positive results. And in his opinion, the blood test sort of results are more conclusive than any breathalyzer test. The CCMA arbitrator was, of course, required to determine whether the employee had committed any act of misconduct and had contravened a workplace rule. And the arbitrator noted that the breathalyzer test may, in certain circumstances, produce false positives, and the more reliable test was your blood sample tested by laboratory. And whilst breathalyzers were a convenient way to test and I suppose a safe way in the workplace, the chairperson of the hearing ought to have taken the actual lab results into account, as they were more reliable. And on this basis, the arbitrator found that there was no breach by the employee of the workplace rule and confirmed basically that the employee did not have alcohol in his system. Samancor was upset about this and took the arbitrator's award on review on a variety of grounds, alleging that the arbitrator misconducted the nature of the inquiry, that he committed gross irregularities, and he didn't take into account relevant evidence, and basically he came to a decision that was not a reasonable one. And on this basis, the company argued, amongst other things, that the arbitrator, for example, in making his findings, considered whether the employee was intoxicated or not. And this was not the test. They had a zero tolerance approach. It was not necessary for the company to show that the employee was intoxicated or was unable to perform his duties. It was merely required to justify that he did not have alcohol in his system. Another issue that they raised was that the arbitrator misdirected himself, saying that the employee did not have any alcohol in his system, where the lab results doesn't show that he doesn't have alcohol. It sort of can only read up to 0.1 grams per deciliter. So he could have had alcohol in his system. And lastly, that in considering the totality of the evidence, the employee tested positive on 3 breathalyzer tests. And the pathologist's report was not conclusive proof that there was no alcohol in his system. So on a balance of probabilities, the company argued it was highly improbable that 2 breathalyzer devices gave a total of 3 false positive results. And on this basis, the arbitrator committed an irregularity. The court, in determining the review, first explained that whether an arbitrator misconceives the inquiry has to be established on the errors of the law and fact that he has made, and that it's resulted in him diverting onto an incorrect path and failing to address the question asked. And leaving aside the arbitrator's references to the word intoxication, the court found that on the face of the award, he did not actually misconstrue the nature of the inquiry. He was required to determine whether the employee breached a rule or workplace standard. That is what he determined, and his finding was that he had not breached the rule or workplace standard. So on that basis, they didn't believe that the arbitrator misdirected himself in the inquiry. As regards the various irregularities raised and the reasonableness of the award, the court was actually unable to find any misdirection by the arbitrator. The evidence indicated that the employee's blood sample that was analyzed by laboratory produced a negative result. And the expert witnesses testified that blood tests are more reliable than breathalyzer tests. And that, of course, breathalyzer tests were prone to false positive results. So it was not in dispute that the employee's level could have been between 0 to 0.009 liters decimeter. But it was possible that the employee's blood alcohol level could have been 0. It didn't have to be between that level. The court said Samancor had the onus of establishing that there was alcohol in his system, and there was no evidence that definitively demonstrated that he did have any alcohol in his system. Further, to the extent that the company contended that it was improbable that the 2 breathalyzer devices would give 3 false sort of assessments, there was no evidence presented by the company about how many employees were tested on that day. Were there any other positive or negative results generated? So there was no basis on which to reject the evidence given by the pathologist and his view that a breathalyzer could have resulted in false positives, and that a blood test was more accurate. So on an assessment of all the evidence, the court held that the arbitrator's finding was actually one that a reasonable decision maker could come to. And on the available evidence, the actual review was dismissed. So I think as a key takeaway here, which as is said, a lot of people have spoken about, breathalyzer tests, of course, a manner which can be used quite easily within a workplace. It's accessible. It can take place where employees are entering into premises. But this judgment illustrates the issue, or at least the difficulty facing employers when trying to enforce a zero tolerance policy in circumstances where there may be a small amount of alcohol in an employee's system. So if you are using breathalyzer tests and there are positive results from those tests, the argument here is that it needs to be corroborated by the employer with further evidence. So if an employee contested the results of the breathalyzer test, like the employee did in this present matter, you may want to get results from more accurate tests or other corroborating evidence, which could be requiring the employee to do a blood test. If the employee refuses, that's evidence in and of itself to take it forward instead of just relying on the breathalyzer test.
Thank you, Nadine. As expected, a flood of questions for you on this case. First question, will a breathalyzer test be sufficient grounds to require an employee to undergo additional or more conclusive or reliable tests, such as a blood test?
Thanks, Lou. Well, on the face of this judgment, yes, it would. Arguably, when you have a breathalyzer test, you can require an employee to undergo, and there's a positive, you can require an employee to undergo a further test. But of course, a blood sample test, we're dealing with a medical testing here, health information. So the employee would have to consent to that. So should ask an employee, should do the test. Of course, if an employee refuses, that in and of itself would be evidence that you can, use to corroborate the findings. But yes, you can then take it further and do a blood sample test.
Next question. In light of the case, will a breathalyzer test be sufficient to prevent entrance to a factory or prevent operation of heavy machinery? This needs to be tied to any disciplinary proceedings or consequences.
So that is a good question. And here I think obviously it was the consequence that resulted, in this judgment and the seriousness of what the employee consequences were for it. Often you do get companies, specifically mines, other operations where they're using heavy machinery that use breathalyzer tests, even for guests that come and visit the premises, and people are refused if they, refused access if they don't comply or they fail the test. I will, subject to anyone else's views on the score, I believe that is sufficient. You're refusing access until, they can come back and have a sort of negative test. Here they just summarily dismiss the employee as a result, which is different in terms of just refusing access for that day to the company. So if you are going if it's going to result in serious employment consequences like a summary dismissal, a breathalyzer test on the face of this judgment is arguably not sufficient. However, if it's simply just to refuse access to premises on that day, that would be a different consequence. If it's contested by an employee, you may want to say, well, go and get a blood test, and once we receive those results, you'll then be allowed access into the premises if they come back negative.
Next question. How should employers handle alcohol breath tests in the future? Blood testing will be troublesome as employees will not agree.
That's a good question, and zero tolerance approaches. I know there's been a lot of questions by employers in terms of how these are enforced, because it can result in, as we said, false positive results, and you could then not have employees attending work. The difficulty is, as I said, on the face of this judgment, a breathalyzer test may not be sufficient, but it's still very factually specific. The employee here did contest the test. He denied any alcohol usage. He got a pathologist. On the facts of this matter was determined that on a balance of probabilities, it may be that the results were, a false positive and the lab results are better. It's not to say on the basis of other facts that wouldn't be the case. Blood tests can be quite, difficult, and employees can refuse them. But as mentioned, the refusal itself could be corroborating evidence. If an employee contests it and generally, believes that they don't have it, they should go and have the blood test done, which is going to be sent to do. So again, I think it's just very factually specific on a balance of probabilities. And then if employee refuses a test, which normally is set out in the policy as one of the factors that can be considered, then, a breathalyzer test may, together with a refusal, be sufficient for dismissal.
Okay. Thanks. Next question. Don't worry. Also last question. Would it be viewed as sufficient if an employer uses the breathalyzer test as well as an observation test, i.e. employee's breath smells of liquor, speech is slurred, movement of limbs, walking, balance, etc. is uncoordinated, eyes are bloodshot, expression is dazed? So can you consider those other factors? Are you allowed to?
Yes, certainly you are allowed to, and I suppose corroborating evidence is not necessarily only a blood sample. Evidence in respect of physical tests like that is definitely would be used and would be recommended. Obviously, how that goes, you go about that is dependent on the specific facts, but definitely in those circumstances, you would use that evidence to corroborate it, and it may, be sufficient in those circumstances. Again, the difficulty in this case was that it was a zero tolerance approach. So they didn't require an employee to be intoxicated to the extent that you could smell alcohol. They couldn't walk on a straight line, the famous test that you do, because even a slight bit of alcohol, whether it actually impacted their ability or not, could still be a risk in an environment such as Smancor. So it could obviously assist to demonstrate potential intoxication, but in a sort of zero tolerance approach, it may be that there's no other factors to assess that, and a blood sort of test would be the only way in which to do that.
Thank you. Thanks very much, Nadine.
Thanks, everyone.
Moving on from alcohol testing, but still on the subject of narcotics, we're now moving on to cannabis in the workplace. In this regard, Talita Lapsha, who's a senior partner in employment practice in Johannesburg, will be dealing with the case. Thanks, T.
Thanks, Lou. Good morning, everyone. Yes, this is a Labour Court judgment, and it was heard by Judge Ratkenike down in Cape Town. It is the case of Marasi versus Petrosa, and it relates to an unfair discrimination claim by Mr. Marasi. Now, Mr. Marasi was working in the Cape Town premises of Petrosa as a telecommunications technician, and he claimed that he was unfairly discriminated against on the basis of culture. He sought an order for 3 months compensation in respect of a period for which he was allegedly suspended without pay, damages in the amount of 250,000 for the impairment of his dignity, past medical expenses, emotional distress, and he also sought an order that Petrosa's alcohol and substance abuse policy had to be reviewed. Now, he was employed, as I said, in Cape Town. He got a calling to be trained as a traditional healer, and he then asked his employer to be transferred to the Mossel Bay premises because that was much closer to the site where he needed to get his training. The training was going to be for a period of 18 months. Now, the company agreed, but they specifically said, remember, you are subject to the company's entrance requirements, which includes a health screening. And at that point, no mention was made that he would be using cannabis as part of his training. Now, at Mossel Bay in particular, there are very strict safety requirements that they need to comply with. And the court recorded the following as common cause facts, actually. It said, Petrosa's core business is the exploration and production of oil and gas. There are strict adherence to safety protocols required. and even just for entry into the operation of the refinery. These are required for the purpose of ensuring the safety of all employees and third parties on site. They are therefore subjected to an annual medical assessment as well as ad hoc inspections to ensure their fitness for duty. They may have no intoxicating substances in their bodies. None of these can be brought into the refinery, and they are subject to random individual and group drug testing. They are breathalyzed. All employees are breathalyzed daily prior to being permitted entry into the refinery. And again, these are to protect the safety of all the employees. The purpose of this policy is to ensure the maintenance of a safe working environment, the health of employees, and compliance with the Mine Health and Safety Act. So, Mr. Marasi went, he was transferred, and he then didn't pass the entrance test. He was denied access to the premises, and it meant that he couldn't come in to perform his duties at Petrosa's premises until he had a clean certificate. So he took annual leave and sick leave, during which period he was paid, and eventually he was back at work with a clean test. He was, of course, not very happy because he then had to suspend the training, and he then lodged a grievance. He said, cannabis is no longer illegal. The Prince judgment in the Constitutional Court confirmed that. The company had to use him as a pilot study to see if their policy is actually in order, and they needed to review their policy because actually, this was not a fair rule to apply. Now, he was required to work at heights. So I just want to give some insight into the jobs, the work that he was actually performing. Sorry, I just need to find this quickly. So he was a telecommunication technician, and he had to look after the telephone service and PABX. He also had to look after Petrosa's virtual systems, attending to video conferencing systems, and if he wasn't alert or if he was under the influence, this would impact on the operations of the refinery. He could be required to climb up to heights to troubleshoot a connection fault. And there were other sites at Mossel Bay that Mr. Marasi could be expected to go to, as they had telephones, such as the harbour storage facilities, the tank room, the heliport, and to ships and rigs. And he had, when he had to go onto a ship and a dam, where he had to perform his work, it could be as high as 140 meters. So that was the context of his own job. And if he was under the influence, that severely impacted on his ability to actually perform those functions. So he didn't resign, he remained an employee, but when the grievance wasn't determined in the way that he asked it to be determined, he referred a dispute to the Labour Court. And as I mentioned, that was an unfair discrimination dispute based on culture. He said that this was unfair discrimination because he was required to use cannabis in his training to become a traditional healer, and he was now not properly accommodated. He also referred an unfair suspension claim because he said when he was told he had to be away from work until he brought a clean test result, that was without pay, and it was procedurally unfair because, you know, the people at the gate couldn't tell him to go home. This needed to be done in accordance with a fair process by members of senior management. The court said no, it is not necessary for a procedure to be followed before you are sent back home in these kinds of circumstances where you are testing positive. And in any event, this time period wasn't unpaid. You were given leave, which you took, and there was therefore no merit in the unfair suspension claim. As regards the unfair discrimination claim, the fact that cannabis is no longer illegal was neither here nor there. The policy applied to legal and illegal substances, so that didn't take the matter any further. The question was whether this policy is an inherent requirement of the job. The court said if it is, then that is a complete defense to a claim for unfair discrimination. The court looked at that policy. Everyone was subject to that policy. The court said, given the circumstances of Petrosa's premises in Mossel Bay, this is reasonable. It is in line with the applicable safety and health legislation, and there was no evidence to suggest that the policy was and the limits on entry was in any way unfairly unfair or unreasonable. There was also no suggestion that the legislation underpinning this policy was unconstitutional, and the court accordingly decided that there was no discrimination, and that claim was dismissed. Any questions? Let's see.
Not yet. I think let's move on. If questions
Sure.
do come, I'll go back to them. So the next set, well, one case that we'll be dealing with now is on discrimination. Well, two cases, and both of them, well, the first one will be dealt with by Talita, and the second one will be dealt with by Rosalind Davey, who's also a senior partner in our employment practice. Both of them dealing with the topic of discrimination.
Thanks, Lou. Mine is an interesting one. It came to the Supreme Court of Appeal, and it related to a claim for damages because the employee said she resigned prior to reaching retirement age. She said she took early retirement 7 years before the date on which she was actually supposed to retire. And that was as a result of severe victimization by her superior. Now, this case is the case of the MEC for Education in KwaZulu-Natal versus Ms. Singh. Ms. Singh is the employee that we are talking about. She was a teacher. She was complaining that for about 11 years, she was subject to severe victimization by her principal. And there were various incidents that she mentioned. For example, she would raise complaints with the principal, and the principal would just make them out as petty complaints, while in fact these were very serious complaints regarding the behavior of children and abuse of children. There was allegations against her that she breached confidentiality when there was no basis for making that allegation, and the principal actually marching into her classroom and making those allegations in front of the kids. She had to submit her English paper to the principal for moderation. She was the only one that was supposed to submit her papers to the principal, and he basically said needed to be redone, which she did. And then she applied to become the head of department, and she said, you know, this is completely unfair because the principal is sitting as part of the committee that will consider this question and well, this appointment. And actually Mr. Padiachi was then removed from that committee that would consider the application, but she wasn't ultimately appointed. So then a couple of years later, Mr. Padiachi removed her from the subjects that she was teaching, and she was now required to teach science. And that caused her a lot of anxiety because this is now a new subject for which she now needed to prepare. Her teaching load was increased substantially, and she complained about that. But then the principal stopped talking to her and, you know, really just ignoring her. There was an incident when she was excluded from the awards day ceremony, all kinds of interpersonal problems between her and the principal. So all of this went on, as I said, for a period of 11 years, and she then retired early. She sued the department for remuneration damages for the period between her resignation and when she would have retired at the age of 65. And the High Court actually agreed and awarded her damages in the amount of 1.3 million. The department then took this matter on appeal to the SCA, as I said, and the department looked at this and said, actually, you know what, we need to understand whether there was wrongful and negligent conduct on the part of the department in this matter. We need to keep in mind that Ms. Singh and Mr. Padiachi were both employees employed by the department. Yes, there was a subordinate relationship between the two of them, but actually they were co-employees. So Mr. Padiachi wasn't the employer. He was his supervisor, but employed by the same employer. And the court said it is important to look at whether this conduct by the department was in any way wrongful or negligent, and even if causation was proved. So conduct will be wrongful where there is a legal duty on a party to prevent the damage that you are complaining about. And that is particularly where you are saying your omission, your failure to act caused me damages. So the court said, we need to look at the legal framework here. First, we have the Employment of Educators Act. That act makes provision for the discharge of ill health on the basis of ill health. It also makes provision for termination on the basis of misconduct. We have the LRA. Under the LRA, there is the Personnel Administrative Measures document that applies to educators. There is a policy on transfer, and there is a policy on ill health and retirement. So where an employee complains about ill health and depression and things like this, it doesn't automatically mean that the department is responsible. These statutory protections enable an employee to deal with workplace harassment and victimization in any number of ways. Ms. Singh could have lodged a grievance, which she didn't. If she had lodged a grievance, she would have alerted the department to the fact that one of their employees, Mr. Padayachi, was victimizing and bullying her in this way, and they would have been obligated under the Employment of Educators Act to investigate the matter. She didn't choose that route. If she said, I am too ill and I want to retire now because I just cannot stand it anymore, again, there would have been an obligation under the policy on ill health and retirement, PILR as they call it, to investigate and to determine what is the cause of this ill health and causing this employee to wanting to retire early. Ms. Singh did none of this. She did go to a psychiatrist and a psychologist, and expert evidence was presented. But the doctor said, you are not going to get better if you remain at the school. That is what the doctor said. It didn't say you must retire early. There were other options available to her, like bringing a grievance, asking for a transfer, or saying I am too ill to continue to work here, which would have then prompted the obligation for the department to investigate. She didn't do this. She decided she was going to retire early, and the court said that didn't trigger a legal obligation on the part of the department, and therefore the department's conduct wasn't wrongful. There was no legal duty in the absence of having known these particular issues and facts, and the fact that it caused ill health, to have taken steps that would render them liable for the damages that she was seeking. And because there was no wrongfulness, the court said, I'm not even going to look into causation or negligence. And that is it.
Thanks, T. As suspected, a question has come in on the Marasi case. So we need to go back to that for a minute. It says, so in this instance of the Marasi case, his case was dismissed based on the inherent requirements of the job related to the nature of his job requirements. Would the outcome be different if, say, the employee was an admin clerk who is not a safety risk, etc., in comparison to Marasi, who deals with heights?
Yeah, it could be. And the argument would then be that the measure is going too far. So, and this is an assessment that needs to be made on a case-by-case basis. So you would need to say, is this a genuine inherent requirement for this particular role? So because an inherent requirement is an absolute defense, there is a high onus to prove that it is in fact an inherent requirement and that it is genuine. In this case, the court said it was. In the case of an admin person, arguably not. You know, that kind of strict levels of intoxication might not be. But again, it's not just, you cannot just talk about an admin job in the abstract. You would need to look at the jobs within the context of that particular employer. So it might be that, you know, they are walking on, you know, installations and stuff, that might cause problems. So it is a very fact-specific question, but you are right, it is an inquiry into the inherent requirements of that job.
Thanks, Talita. Over to you, Roz, and your case on discrimination.
Thanks so much, Lou. Good morning, everyone. So the case that I'm going to be discussing is Vala versus the SABC, Broadcasting Corporation, and the Broadcasting Corporation's Pension Fund. Now, the facts broadly of this case turn on a retirement policy and the existence of fixed-term contracts, and whether or not the way in which the SABC conducted itself constituted unfair discrimination based on age. Now, as I think most of you are aware on this call, that if you dismiss an employee as a result of his or her age, that constitutes discrimination. That's the standard test, unless the age or the age is an inherent requirement of the job. So it goes back to the point Talita was talking to, was there an inherent requirement of the job that required people of a specific age, for example, or if the employee has reached the normal or the agreed retirement age. Now, most of the cases we deal with is whether or not there's a claim of a normal or agreed retirement age. So in this case, what happened is that SABC had a retirement policy. They also had the pension fund, and in terms of the pension fund rules mirrored the policy. What this policy provided was that there were two retirement ages. The first retirement age was the age of 60, and that was for senior management employees or employees at the level of a general manager. And then the other retirement age was 63, and that was for all other employees. Now, it is unclear from the case why there was these different retirement ages for senior management employees. Now, at some stage, the board started looking at it, and they wanted to change the definition of an executive general manager, and to make the executive general manager something more than just an ordinary general manager, and then to apply a different retirement age there and to increase it to 63. But I'm not going to go into huge detail there. The crux of this case is that in about, I think it was August 2015, the HR executive and Remco reached or proposed that they change to two issues. One was with regards to fixed term and contractors, and the other was the retirement age. And it seemed that what they had was a lot of fixed term contracts for employees who are de facto permanent employees. And they said, look, where we have people in positions that are permanent positions, and these people are on fixed term contracts, we need to convert them to permanent positions. And then they started looking at this issue of the retirement age and had proposed that they increase the retirement age across the board to 63. Now, Miss Vala was I'm not certain exact position, but she was one of the general manager positions. So she was a senior manager. She was also on a fixed term contract. Now, she was one of I think the deputy company secretaries, so a senior executive position. Her fixed term contract was for the duration approximately March 2013 to April 2018. Now, the April 2018 date coincided with her 60th birthday. So it would appear that it was aligned with her retirement at the age of 60. And she was due to turn 60 in May of that year. In about 2017, the HR executive took these discussions forward regarding the increase in the retirement age and regarding the change or the conversion of employees to fixed term from fixed term contracts to permanent. And the result of this was that a resolution was passed by the HR executive together with the REMCO, which was a subcommittee of the board. And the resolution said that approval is given to convert GM, which are your general manager level, to permanent employment where they are in a position that is in fact a permanent position. So where it's not a project-based position. And the reason for this was it was to be an incentive to buy in and for the retention and for leadership continuity. And then it was also to assist these GMs with their pension benefits to ensure that they were equitably treated and insofar as group life, etc. was concerned. So this resolution was passed in November 2015. Subsequently, it was then ratified by the board of directors. So it became a board resolution. In the same month, I think it was, Ms. Valla was informed by one of her colleagues, I think one of her senior colleagues, that as a consequence of this resolution, she was now a permanent employee and her retirement age had been extended to 65. So no changes are made to the contract and no changes are made to the policy or to the retirement fund rules, which aligned with the policy, which was the 60 for management employees and the 63 for all other employees. So Ms. Valla continues believing that she is now a permanent employee and that she will retire at the age of 63. Approximately a year later, so and in fact, I'm sorry, I've jumped. This all happened in 2015. In 2017, about 6 months before her contract was due to terminate, she got a pension fund statement and was concerned when she saw that the pension fund statement recorded her retirement age as 60. So she then approached her boss or her superior and she said, "What gives? I was told a year ago that I am now a permanent employee and that my retirement age is 65. And why now is my on my Provident pension fund statement saying that I'm going to retire next year?" She was then told by SABC that in fact the resolution had never been implemented. So yes, there was a board resolution, but for unknown reasons, that resolution had not been implemented. And the advice that she was given was that she should now apply for the extension of her fixed term contract to the, so that she could then continue to work until she was 63. She was dissatisfied with this and she lodged a grievance. And the basis of her grievance was, there is this resolution. The resolution makes me a permanent employee and has extended my retirement to 63. Accordingly, being told that I now have to apply for an extension of my contract is unfair. Her lawyers also engaged with the SABC. Now, strangely, at this point, the SABC sort of dug in their heels and said, no, you know what, this resolution wasn't implemented. And then they started looking at her position as a deputy company secretary. And they said, you know what you have done is to take confidential company information, give that to your lawyers, and now you're trying to use that improperly against the company. Now, she was then charged and she was told she needed to make representations. This was all in early March of 2018, in circumstances where the SABC was still saying your contract in any event expires at the end of April. Her lawyers then, on her behalf, bring an application, although they disputed the need to do it, and they reserved rights, they brought an application for an extension of her retirement age and her contract to 63. The company then came to her and said, oh, we've considered your request for an extension and we are not agreeing, and your employment is going to terminate on the 30th of April due to the effluxion of time. And ultimately they terminated and she was left unemployed. Dissatisfied with this and with the way this was handled, she then approached the Labour Court. And she approached it, she had a number of claims, and primarily the claims were that her termination was unlawful, that her termination amounted to a dismissal that was automatically unfair, and that she had been discriminated against. And the claim for discrimination was based on her age. She also tried to say that the policy or the application of the policy and how it had been applied to her constituted an unfair labor practice. And she requested that the court determine this because the facts were the same. Now, ultimately, I think we're all aware that unfair labor practice disputes go either to the CCMA or to an appropriate bargaining council. And she sought to have the court exercise a discretion to find that it had jurisdiction based on the fact that these disputes were all integrally connected. The court said no. The court said, yes, the facts are similar. Yes, it's the same evidence, but we do not have jurisdiction over an unfair labor practice dispute. And the court decided that it was not going to deal with that leg of the claim. Now, throughout the court case, SAB's position was, firstly, Ms. Valla was employed on a fixed-term contract. The fixed-term contract terminated due to the effluxion of time, and therefore there was no dismissal. And then they said, insofar as the retirement age issue is concerned, this is not unfair discrimination. We have a policy. The policy provides that all general managers retire at the age of 60. And that is the normal or the agreed retirement age. When considering normal or agreed retirement age, the court said that's an either-or claim. You either go on the fact that you say 60 is the normal retirement age, and then you've got to establish it's either normal for that category of employees in the industry, or possibly it's normal for that category of employees within the employer, or you can claim an agreed retirement age. You can't claim both. You can't say, well, we think it's this, but if it's not that, then it's this. So the court made it very clear it's an either or. So it's important to remember that when considering your retirement policies, etc. Anyway, so the SABC then pinned its case on this, the retirement policy, and didn't really deal with the resolution. And what the court said was that it was common cause, that the GM positions were not project-based positions. They were de facto permanent positions. The court also said that the resolution was clear that all GM positions that were not project-based positions would be made permanent. And the court said on that basis, Ms. Valla was a permanent employee. So insofar as the claim that her contract terminated due to the effluxion of time and was therefore not a dismissal was concerned, the court said no, she was dismissed. Then the court turned to determine, was the dismissal discriminatory? Was it an automatically unfair dismissal? So they then looked at what was the reason for her dismissal. And it's very, very clear on the facts of this case that the reason for dismissal was the fact that she turned 60. So it was based on age, and the court then accepted that a dismissal was based on age. The court then said, okay, well, was this an agreed retirement age? Now, SABC went to great lengths to argue that they had the policy was clear, it was 60, and the resolution was actually silent on increasing the retirement age. The resolution talked about the conversion of these contracts to permanent employment. And the court looked at this and they're like, well, the resolution, when read holistically, is very clear that the purpose was to ensure retention of skills. It was to ensure leadership continuity. It was for incentive buy-in. It was to give equity when it came to pension benefits, when it came to life insurance. And the court then said that this resolution clearly created a scenario where the retirement age for general managers, including Ms. Vala, was extended to 63. And therefore, the court said you can't rely on the policy to say that 60 is the agreed retirement age. So based on this, the court found very clearly that the termination of her contract was a dismissal. The dismissal was based on age and therefore a discriminatory ground. It was not based on normal retirement age or an agreed retirement age, and it was not due to the inherent requirements of her job. So her dismissal was found to be automatically unfair. And what the court said was the dismissal was an unlawful termination. The termination amounted to a dismissal. Ms. Vala was subjected to unfair discrimination in terms of the Employment Equity Act, and her dismissal was unfair. Now, Ms. Vala had requested that she be reinstated, but by the time this matter got to court, it was actually after the age of 63. So she would have retired anyway. And the court said, therefore, they needed to look at the compensation equal to a maximum of 12 months, and then patrimonial damages as a result of the fact that she was subjected to unfair discrimination. Now, that decision, the decision as to what compensation she would be granted and what the patrimonial losses were, was postponed sine die, so we don't know what the ultimate result was or will be there. But I think this is a very, very important case for employers who have retirement policies, who have retirement funds that have specific rules. It is very important to ensure that there is a fair rationale for the ages, that there isn't discrimination. It didn't form a significant part of the reasoning of the court, but the court did find that general managers were also discriminated against in the policy. So although it wasn't particularly relevant to the outcome, because the resolution was found to have extended the retirement age anyway, it was important because the court found that there was discrimination there. So be aware when drafting your policies, when implementing your policies, that you can justify any distinctions, that there is a rational justification for that, and that it's not in itself discriminatory. And then when it comes to agreement, what was very interesting, because a policy in and of itself may become an implied form of the part of the contract. It may become a tacit agreement. And what the court said here is, yes, they accepted that policy, that 60, the age of 60 was an agreed retirement age. But they said in passing the resolution and extending the retirement age, that in itself is not an agreement. But Ms. Vala, in accepting it and saying, yes, I'll retire at 63, she had then accepted the age of 63 as the agreed retirement age. So just bear that in mind. It's an important case, and it can trip us up. That's that.
Thanks very much, Ross. There is a question for you, but also bearing in mind that we still have one more case to do on the very important question of restraints of trade. So just quickly on this question before we move on to the case on restraints of trade, can the employer postpone the date of retirement due to knowledge transfer, and is an addendum satisfactory versus a fixed term contract?
By agreement, yes, you can. So I have no difficulty with that. Personally, I think a fixed term contract is far cleaner. So you could do an addendum in terms of which you fix the term. What you don't want to do is an open-ended addendum, because then you cannot later rely on the fact that the person is over the retirement age. And I think in one of these ELUs, we've actually discussed a case, I can't remember the facts, where the court said if you ignore your own retirement age and by agreement the employee continues to work indefinitely, you can't then terminate based on age. So very important to make sure any addendum or fixed term contract is limited in duration and that you set out exactly when that contract will retire, will terminate, and then it becomes a termination due to the effluxion of time. And I think it would be easily one where you could justify the purpose of the fixed term contract. Thanks,
Rob. On to restraints.
Okay, so I'll be very quick on this one because I see we have run out of time. This case is Tasneem Sadan and Nicholas Arujo versus Workforce Staffing Pty Limited. Now, Workforce is, let me just actually tell you exactly what they do. They provide services to clients. So they have clients nationally in which they provide some partly labor broking services, but it's not limited to labor broking services. They have staffing solutions, they have payroll administration, they have HR solutions. So it's a service provider company. So there's a lot of relationship issues there. Now, as a result of it being very dependent on client relationships and the service, there are restraints of trade for its employees. Now, the two employees in this matter were both involved in sales. Sadan was the general manager of sales, and Arujo was the national sales executive. They were both subjected to a restraint of trade, and the restraint of trade, in essence, prevented them from working for a competitor for a period of 2 years. Now, I'm sure, everyone, we all on this call know that in South Africa, a restraint of trade is enforceable. So the primary position is the restraint of trade is enforceable. But that isn't where the inquiry ends. What you have to show as the employer is that you have a proprietary interest worthy of protection. So you need to justify the restraint. So you cannot, for example, subject your cleaner to a restraint of trade because what is your proprietary information? You can't subject your tea lady. You need to be able to show that the person who has the restraint has access to your proprietary information, that has access to your key clients, and can actually cause harm or put that information and that interest at risk if they go elsewhere. Then the restraint also has to be reasonable. And generally, when looking at reasonableness, you're looking at geographical location and you're looking at duration. Now, in this case, this was a matter before the Labour Appeal Court, and it doesn't appear to be contested that there was a proprietary interest worthy of protection and that this was at risk. Both of the individuals were sales execs. They had access to pricing structures and strategies of the company. They were involved in and knew about the development and implementation of sales strategies for the various regions in South Africa. They knew the profit margins, and they worked very closely and had very, very close relationships with the clients and customers of the company. So definitely a proprietary interest worthy of protection. What they said, firstly, was that the restraint of trade was unclear because it didn't really establish a geographical location. But if it did establish a geographical location, this was 50 kilometers from where they worked. They worked in Cresta, so they said that they could go and work anywhere else in the country, and that was fine. And what had happened is they both resigned. They'd both taken up employment with a direct competitor of Workforce in different regions. So the argument was, well, if we're bound by this restraint, we're only bound within 50 kilometers of Cresta. There was a fundamental dispute about that because the Workforce said, no, What the contract says is it's 50 kilometers from your office and any office where you are intricately involved. So wherever you actually are rendering services, and because you are both national sales and you are dealing with customers nationally, this is a national restraint of trade. So that was one of the questions the court had to determine. And then the other question was this 2-year restraint. And what the employees said is, well, we're prepared to accept a 2-year restraint in the event that the geographical location is limited to this 50 kilometers around Cresta. But anything beyond that, 2 years is unreasonable. And the court then looked at the whole issue, and it confirmed that there was a proprietary interest worthy of protection. It confirmed that the proprietary interests or the interests of the company were at risk. So then it was to look at, well, now we need to balance the rights of the company versus the rights of employees to be gainfully employed and to follow their career choices. The other question is the issue of the sanctity of contract. Now, in South Africa, we've got a principle called the Pacta Sunt Servanda. And what that principle says is that he who enters into a contract freely and voluntarily must be held to his or her obligations under that contract. And that's a public policy consideration. And the court said, for that reason, restraints of trade must be upheld. When it came to determining geographical location, the court said, insofar as there was the so-called dispute about geographical location, that was a non-starter argument by the employees. The employees worked with customers nationally. It was therefore a national restraint. And given their close relationships with the customers of the employer, it was reasonable. They then turned to look at the 2-year restraint. And in that regard, the court said, in order to justify a 2-year restraint, you need to show very, very clearly why you need 2 years, why the employee is still going to do you harm after, let's say, a year. So, excuse me, the principal point with the restraint of trade when coming to duration, and I think rule of thumb, a 6-month restraint of trade is reasonable. And I think up to a year restraint of trade, usually it's going to be reasonable. And the courts are generally quite ready, as long as there's a proprietary interest worthy of protection, of enforcing a 1-year restraint. But when it comes to 2 years, what the Labour Appeal Court here said is you need, as the employer, to show that, for example, you have a specific lead time in relationships. So if negotiations with prospective clients, for example, typically take 2 years, and these employees were involved in the initial stages, but it's actually going to be 2 years before you reach the conclusion, then you might be able to justify that lengthy restraint. But ordinarily, it is likely to be found to be unfair. And in this, the other thing to remember when you are writing your restraints, or where you are looking at or advising your attorneys on restraints, is you need to, we always put the clause that each clause is severable. It can be first enforced to the maximum, but otherwise limited. The courts do not like to red pen your agreements. They do not like to come and say, okay, you've got this agreement. Well, we don't like geographical location, so we're going to amend it for you. And we don't like duration, so we're going to amend it for you. The courts are not going to amend your agreements for you. However, in this case, the court said, you know what, we're not going to enforce it for 2 years, but we will enforce it for 1 year. And they reduced the duration. So it was actually, it was a good result for the company. But just bear in mind, that's not always the court's attitude. And we've seen cases where the court says, it's not my job to rewrite your agreement. If you've written your agreement and it's wrong, you need to accept that it may be set aside as unenforceable.
A question, Roz, if it is 2 years, but with pay, is that reasonable?
The issue of payment is always a tricky one. So the first thing to remember when it comes to restraints is you don't need to pay employees to make a restraint of trade binding. It does, however, assist when seeking to enforce it, and it may be something you can rely on. The counter argument that an employee might have is, yes, I'm being paid, so I'm not financially out of pocket, but as a consequence of this ultra lengthy restraint, I am not able to enhance my reputation. I'm not learning on the job, and I am therefore, at the end of the 2 years, going to be prejudiced because I'm not going to be as easily employable. So there will be a counter argument. It is a factor for consideration, and it is a factor that the court will consider and may well find that it justifies the 2-year restraint, but it is not the only consideration, so it might not be enough. Thanks, Lou.
Thanks so much, Roz. Thanks so much to our audience for staying with us. We are well out of time. And thanks so much for our presenters for giving our audience this case law update this morning. See you all next time. Right.
Thanks, everyone. Have a lovely
Thanks,
weekend.
everyone.
Bye.
Cheerio.